Good morning. Um, we are going to get started. I'm just going to let you folks know that this webinar is recorded, so it will be posted on YouTube later on today, so you can rewatch it back. If you would like to, if you have any questions, you can either use the Q&A box in your on your bottom part of your screen, or you can put it in the chat, and we'll be taking questions at the end of the session. So I will introduce your speakers. Stuart is a partner in the Halifax office. Stuart brings over 15 years of experience in commercial litigation with a focus on contractual, shareholder, trademark, copyright, and patent litigation, as well as medical defense litigation and professional regulation. And here from Springboard Atlantic is Shelley. So now I will pass it over to Stuart and Shelley.
Great. So I'm going to get started, and Shelley's going to add some material at the end. I'm going to share my screen because I have some slides, and you just have to indulge me for a moment while I do that. Okay, great. So I was asked to speak today about strategic management of intellectual property assets. And so the agenda for today is I'm going to introduce myself, a little bit about me, which will help inform my viewpoint. I'm going to speak about the different types of intellectual property, the four main sort of categories of intellectual property. I'm going to talk about the way in which you go about protecting each type of intellectual property, because the way you do that is different and unique and to each type of IP. And then we're going to get to the core aspect with that sort of all that background, which is the strategic management of IP assets. I'm happy to take questions throughout at any time. So whatever mechanism you want to employ to get a question to me, I'm happy to stop anywhere along the way and have address a question and then move on from there. So a little bit about me. I did a science degree and a graduate degree in science before going to law school. Before law school, I also worked at a company in Vancouver, a software company. At the time, it was known as ALI Technologies. It's now since been purchased by McKesson. And that company was a software development company in the field of radiological imaging. And so that was a company, just for context, so you have some idea about me and questions that may be worthwhile asking. It was at the time, I think they had about 60 or 70 employees, publicly traded company. About 40 of those employees were software developers. It's grown much larger since then. After law school, I worked at a law firm in Toronto called Gowlings. And then after that, I worked at a technology company called Ballard Power Systems. So in Vancouver, Ballard develops fuel cell technology, which is akin to battery, but with some significant differences. And then in 2010 or 2011, I came back to Nova Scotia and joined Cox & Palmer, where I am now. So at Cox & Palmer, it's a full-service law firm, if you're not aware of us. In my area, I do a lot of IP protection and IP litigation. So I come at this from two different angles, the litigation side and the protection side. I advise on IP issues in corporate commercial matters, deal with, we as a firm, of course, as a full service law firm, deal with all sorts of things, real property, immigration, employment law, anything that may come up in your day-to-day business. As I said, in my area, I'm focused on issues of brand protection, so trademark, technology litigation, so anything involving technology or software associated with therewith, and then sort of the core intellectual property litigation, which would be patent, trademark, copyright litigation. And I also get involved in things like confidentiality agreements and NDAs. I did a session a couple months ago at Cove in Dartmouth, where the whole session was about confidentiality and agreements and NDAs. The subtitle of that was, you just sign them, right? And wrong. So I could speak at length about confidentiality agreements and NDAs. And if there's time, I will. People tend to sign them without giving a lot of thought as to what they're committing themselves to in doing that. And I'm happy to take questions about that at any time as well. I always like to throw in a little reminder that when you're signing a confidentiality agreement, there are obligations that come with it and potential pitfalls that come with it. It's not just something you pull off the internet and sign and move forward. So the types of intellectual property. So when you're thinking about strategic management of intellectual property assets, you have to first identify what the intellectual property assets may be. And there's four main categories. There are others, but there's four main categories that you're going to encounter in your day-to-day business. One is inventions, so things that are protected by patent. So inventions are new and useful ways of doing things. And I'm going to get into each one of these, so I won't spend too much time here. But the second one is your brand, your trademark and your brand. And as we are getting ready for this session, I was going through the member directory for Digital Nova Scotia, and almost everyone has a very, you can tell time and money were spent on developing that brand, the logo, the brand, the name of your business. The third category is artistic works. And so this is your traditional artistic works, books, poems, sculpture. But because it protects literary works like books and poems, artistic works are also computer code. So source code, not necessarily object code, but source code is considered an artistic work in the legal world and therefore protectable in the same way as books, poems, and sculpture, which would be protectable by copyright. And then the fourth type of intellectual property is stuff that you keep confidential. Everything else that I've talked about is sort of outwardly facing IP. Confidential information and trade secrets is also sort of a category of intellectual property. It doesn't carry with it the descriptions that I'm going to give in a few minutes about how to protect it, because I can, but it doesn't have an outward protection mechanism. It's all inward in how you handle your confidential information and trade secrets. So I'm going to come back to this, but the first thing that you need to do is really take a look at this list and think about, what do we have in our business, or what are we working towards in our business that may fit into one of these categories? And I'll come back to this again, but you should know what these things are. Like, have a list. Even if there's one thing on the list, you should have a list. Identify what it is, and then build upon that list as your business grows, and so that you have a good inventory of what IP you have and what you're doing to protect it, what the status of it is, where it came from, all those sorts of things. So like I said, I'm going to get back to that. I wanted to give that little preamble. So now I'm going to switch gears a little bit and talk about each one of these pieces of intellectual property so you have a better understanding as to exactly what each of them is. So the first one is inventions protected by patent. So again, an invention is a new, non-obvious way of doing something. And I'm going to give an example. Let's see if this works on the screen. I think it's a good example. I've used it many times. So you may, if you're old enough like me, you may remember that if you went to the library and checked out a book, they would take a stamp and they'd hit it on the ink pad, and then they'd stamp the book. And then time went on and people developed a new type of stamp, and that's a stamp like this one. And it has an internal ink reservoir and this stamp pad. And so when you push down on the page, this will stamp the embossed wording. In this case, it's the word draft, embossed wording on the page. Problem with this is that it's open to the air, and if I touch it, my hand will get inky. And when I'm not using it, I have to put it in this case to keep the ink from drying up. Okay, so it's a better system than the 100-year-old, 200, 300-year-old system, but it's still not perfect. Then someone came up with one of these. You may have seen these before, and this is a similar device, but the ink pad is not exposed to the air. It tucks up, it rotates. If you can see that, it rotates. When I push down on the page, it rotates from being up against the ink pad, rotates, and then is available at the very moment it makes contact with the page. So when I let go, I don't have to put it in a carrying case. I don't have to worry about touching it. And this little cam, there's a little track here, and it articulates. And so that's a a minor improvement on an existing technology that really renders the existing technology obsolete. And when you go to the store and you want to buy a stamp that says the word draft on it, you're going to buy this one most likely, and this may cost a couple dollars more, but it's a disruptive technology in that sense. It replaces the original technology. This is no longer viable. Nobody wants it. You get one of these instead. And so this is an invention that's protectable by patent. And it's to get a patent on that, you have to apply and you have to be granted a patent. And the process is onerous and difficult and expensive. But if you obtain that patent, you have 20 years of monopoly. So you can be the only one selling this and corner the market on this for 20 years and reap the benefits of your intellectual property. But you have to apply for a patent in each country where you want to have protection. And if you don't have protection, if I only protected this in the United States and Canada, someone in Great Britain could replicate this and manufacture and sell it without any recourse by me. You need to have a patent in each country where you want to have protection. And one of the downsides is if this was, well, I'll take a step back. This is obviously a clear mechanical device. It's easy to reverse engineer. If I was to buy this on the shelf, I could easily reverse engineer this, maybe even 3D print it and replicate it. The only thing stopping me from doing that is the legal instrument, which is the patent. But for processes, ways of doing things or ways of making things, it may not be obvious from looking at the finished product what the process was to get there. So for example, there may be an anti-scratch coating on my iPhone, and I can cut this phone in half and I can look at the layers of the substrate, but it may not be obvious to me how they got that upper layer to adhere to the second layer. There may have been an ephemeral layer that was put in between that evaporated. It may have to be electrostatically at a particular charge. It may have to be deposited by a spray nozzle of some particular way. It may have to be deposited at a particular temperature. All that's not obvious from looking at the finished product. So if you apply for the patent to protect that process, you're disclosing the technology to the world, which may not have been disclosed otherwise than by looking at the product. So if the patent is not issued, if it's not issued for whatever reason, then you've disclosed the invention, but you don't get the benefit at the end of the day of the protection. So when you're patenting something that's mechanical and reverse engineerable, that's clearly the right path. When you're thinking about protecting a process, you should think twice about whether patent is the best way. The alternative is trade secret, which I'll come to. But I just want to lay that out. That's a caveat that a lot of people don't appreciate, that if you're not able to reverse engineer the process from the finished product, you should think twice about maybe applying for a patent. The requirements for a patent is that you have to have an invention, and an invention certainly means this thing, a mechanical device. But that definition of invention has been expanded over the years and is different in different countries. Software, ways of doing things by computer, has different treatment in different countries. And so that's a caveat. It's more liberal in the United States, which is, good because it's a big market. It's more restricted in Canada. But other than having the invention, it has to be new in the sense that it's never been done before. It has to be useful in the sense that it does what you say it does. And then it has to be non-obvious. And to be non-obvious, you have to demonstrate that what you're doing is not just an obvious combination or obvious modification of existing technology. For example, taking this thing, it's green, and making it out of pink plastic instead of green plastic. That's an obvious variation on the existing technology. It doesn't add anything new. And when you're reviewing whether your technology is obvious or not, you have to look at the state of the art globally, even if you're only applying in one country. So you're not just looking at what's been disclosed in Canada. You have to show that this is new and non-obvious globally, and then you can decide where you want to file your application. If the only aspect of your non-obvious invention is something that doesn't make your device commercially better, then you're not really protecting anything that's going to be of benefit to you. On the flip side of inventions and things protected by patent, is the freedom to operate issue. So if you're going to make something, if I was going to make one of these things, or I just came up with this, I independently developed it in my head one day, I thought, wouldn't that be great? I can't start making these things and selling them. I shouldn't, because there may be a patent on this that I'm not aware of. So if you're going to launch a new product, you should check to make sure it's not already been invented by someone else. And if it has been invented by someone else, what you're doing different from that patent in a way that allows you to make and use or sell that device. So I'm going to go on and I'm going to speak about patents a little bit, but I'm just noting that with my screen shared here, I'm not actively seeing any questions or anything. So if there is questions, someone can jump in and let me know. So what is protected by patent is, again, something that's often misunderstood. I've shown here 2 pages from a patent, a U.S. patent issued, and it's for a computer pointing device. It's a sort of a 3D haptic kind of pointing device. Forgive me here. I believe it's a Logitech device. And it has a number of inventors, and it was assigned to Logitech, and they're the ones that filed the patent application. And so this document is, you can get it off Google Patents. Google has its own patent search thing called Google Patents. It's very good. And it has pages and pages and pages and pages of drawings and description. But what at the end of the day, the only things that are protected by the patent are what I've highlighted here, which is at the end of the document. And it says, I know you can't see it, but it says what is claimed is, and then it has a set of numbered sentences. And those are the things that are protected by this patent, not the stuff that's described in the patent document itself. The patent document itself is only there to help you understand these sentences. But the scope of protection is only and is absolutely confined only to these sentences. So that's another thing that I want people to be aware of when considering patents, is that these sentences, they're called the claims, they rule and govern everything about the patents. Again, it's a major misconception, so I like to clear it up. Go back. I'm happy to talk about patents at length. we're already 24 minutes into this, so I'm going to move on. The second category of intellectual property is brands and trademarks. So, brands and trademarks are your outwardly facing image to the public. It's something that is created in the mind of the consuming public. When they see a name or a logo, they think of you. They don't get confused as to who is who. Okay, so the core aspect of your brand, it is that it has to be distinctive. And it has to be distinctive in your sphere of operation. So bottom right corner, if you recognize that, that's a logo for Delta Airlines, a US-based airline. Delta Airlines, that's a distinctive brand in the sphere of airlines. But it's not the only Delta brand in the world. On the left-hand side, I have the logo for Delta faucets. So kitchen faucets, sink faucets, kitchen hardware, Delta faucets. There's also Delta Power Tools and Delta Hotels. They all coexist because they're in a different sphere of influence. So when you're thinking about whether it's distinctive, you have to look at the look, sound, and idea conveyed by the brand within a particular realm of goods and services. And when people come to me and they say, oh, I've got a new brand I'd like to protect. And they tell me what it is. The first thing we should do is to determine whether anyone is using something similar or not. Because you think it's distinctive, but until you do a search, you don't know all the businesses that are using that brand, for example, in Canada. And so you can search, and I've done a search here through the intellectual property website, Canadian Intellectual Property Trademarks website, for the word Delta, and you can see all the various people who are using Delta as part of their brand. And so we evaluate that, and we determine whether your brand is sufficiently distinctive to live amongst these other brands. I will say people often come to me with a minor variation on an existing trademark. They say, oh yeah, but mine's different. It has a K instead of a C. Well, that's not enough. And so it's not about whether it's identical, it's whether it's sufficiently confusing that a general consumer would look at that vaguely and say, oh, I think that's the same. Yeah, that's the same brand, same thing. They'd be confused. So it has to be distinctive. It can't just be a minor variation. It has to be very different. The other thing that your brand, if you're launching a new brand, is that it can't be descriptive. Descriptive trademarks are very difficult to protect. So Google, when the inception of Google, that meant nothing. Xerox, Esso, Exxon, Kodak, all these brands had no meaning when the word was coined and used for that brand. Delta does not necessarily mean it's not airlines. Doesn't mean, I don't know what this is if I didn't already know it. So when you come to me and say, I've got a new brand I want to launch for my computer mouse company. It's called Best Computer Mouse. That's not going to be registerable. It's too descriptive. And the reason is if your product is if your name is descriptive, it prevent other people from calling referring to their brand under the similar. If they said, oh, this Logitech mouse is the best computer mouse, then all of a sudden they're infringing on your trademark, and that's not permissible. So for brands and trademarks, again, you can apply to register that. You can get national coverage by registration. There's an application process. It's reviewed for distinctiveness, what I just described. It's reviewed for descriptiveness. And if you're granted that, you get 10 years of protection for your brand, and it's renewable indefinitely. Unlike patents, the process is relatively straightforward and the cost is relatively cheap for protecting something you may have spent a lot of time and effort in creating your brand. And it's a lot better to protect it on the front end rather than having to change it later or find that someone else is using a similar brand after you and you have to get into a fight with them about it. So if you have a brand and your company brand is distinctive and you're proud of it, you should really think about protecting it. The last thing is artistic works. So again, it's run-of-the-mill stuff: books, drawings, songs, music, sculpture, and computer code. So for computer code, it protects the source code. So it really protects, and I have to think about this, but the idea here is that it protects the literal copying of the code. It doesn't protect the functionality of the code. So I can't copy Microsoft Word on a disk and give it to my friend. That's copyright infringement. But I could sit down and write my own word processing software from scratch. And the fact that Microsoft Word's code is protected by copyright won't have any impact on that because I'm writing mine from scratch. So the analogy in the book world is that there's lots of books. You know, person A meets person B, person A falls in love with person B, they have a fight, there's a falling out, they get back together. That's a common theme across many, many books or movies or whatever. The simple fact that I create a new movie that has that same theme is not infringement. It's a question mark whether the words, the actual literal words, are a substantial reproduction of the original work. So the fourth thing I want to talk about is confidential information and trade secrets. So if your business is, if you're a service provider, you may have a way of doing something that is your secret sauce, that you protect, and people come to you for that service because they don't know how to do it. And you take an input and you have your black box and you spit out an output. And that black box and what you do within that black box is confidential. And that's where you make your money providing that service. So in order to protect that, if you're not going to disclose it to the world through the patent application, you're going to keep it as confidential. You must keep it as confidential. Once it gets disclosed, there's no way to undo that. So you have to maintain it as confidential. And you have to do that in several ways. One, you have to legally protect it as confidential. I'll talk about that. The other way is to physically keep it confidential. So I'll talk about that as well. So physically keeping something confidential is really just keeping it literally under lock and key, password protected, physically separated, locked up, marked as confidential, all these things to keep it away, hide it away from other people. When I worked at Ballard, we had a very large laboratory, and when people would come for tours, they would physically take black covers and put them over certain things they wanted to keep as confidential, so that people could take a tour of the laboratory of the facility, but physically not see confidential stuff. Or it's sequestered in a special room where you have to have special permission to get in that room so you don't see the confidential stuff. So that's one way of protecting confidential information. The other way is through legal mechanisms. So if you have an employee, the employee agreement, their employment agreement, should specify that they are required to maintain confidential information as confidential. The other thing is this bit about confidentiality agreements and NDAs. And people are like, okay, I got this confidential information, I want to share it with someone, or I'm going to be working with someone on a joint development thing. I want to show this to them, so I'll get them to sign an NDA and we're all protected. And that's obviously good. but you should really ensure that you're not just thinking that I got the NDA, everything's fine, I can show them whatever I want. Number one, it's risky because even if they breach the NDA intentionally or accidentally, again, there's no way to get that back. You can sue them for damages, but that's not going to recover and remake your confidential information confidential. I like confidential agreements where it's required to be marked as confidential, to be considered confidential, so you know exactly what you're talking about. But the flip side of the NDA is that people often, well, let's make it two-way. Let's make it bilateral so that, just so it's even. Well, there's a real risk in receiving the confidential information from other people. Once you sign that NDA and they say, okay, here's all our confidential information, you're stuck with that. And you may have signed into that agreement obligations that you're going to maintain that as confidential for 20 years or 5 years or 10 years or whatever. So now you have to not only physically protect your confidential information, you have to protect the confidential information you receive from somebody else. And if you do that 3 or 4 times, now you have to have 3 or 4 different buckets where you keep those confidential information from other people sequestered away, locked, protected. And you may have one you have to keep confidential for 5 years, the other to keep confidential for 10 years. When I worked at Ballard, we had something like over 3,000 confidentiality agreements over the course of 20 years that may or may not have had information flowing in from those. You can imagine it becomes very difficult to ensure that the confidential information that's been received as a result of that is locked away and sequestered in a way that it's not misused within the company. It doesn't propagate out. It doesn't infect other things, all that sort of stuff. So we obviously took great care to make sure that it didn't happen, but that's an example of where, starting with the first one, be careful and keep a list of what confidentiality agreements you have, what the obligations are, and where that information is located. So that's the first half, which is all about the types of intellectual property and some discussions on that. I'm going to take a quick pause there and see if there's any questions. I'm looking at the chat. I see, so I don't see any active questions in the chat. So I'm going to move on and talk about sort of the strategic management of IP assets. So I've talked a little bit about this, but I'm going to get into a little bit more detail here. So the first thing you need to know, if you're going to manage your IP assets, the first thing you need to know is what IP do you have? And so start with a list. Okay, number one, company name. That's a brand. We had a logo made. Okay, who made the logo? Was it someone within your company? Was it an employee? Was it a graphic designer that you got off Fiverr? Was it a graphic designer across town? Was it a friend, right? If you had a graphic designer create a logo for you and your company becomes the next Google and you didn't properly acquire the rights to that logo when they made it for you, they're going to come knocking on your door. They're going to say, I made that logo. I own it. You've been using it. And I want X in exchange for giving up all my rights to that logo. And that X is going to be much, much larger down the road than it is on the front end when you pay them $100 to create the logo for you. Okay. So that's just one example. But what are your IP assets? Your company name, your company logo. Are you a software development company? Okay. What software have you created? Who made it? Where is it? What is it? Is it a really interesting subroutine or something that you created? What is it? Where is it located? How do you identify it? How do you know what it is? Because it sounds simple when you're small and everything. It sounds simple. We know we're all working on the same thing. We know what it is. But as you grow and get bigger and employees leave and new employees come in, and that institutional knowledge can become fuzzy. So keep that list and maintain it. And it should have columns: what it is, where did it come from, who made it, what agreement do we have in respect of that, do we own it, do we license it in, what is the situation. You can make it a requirement for your employees to disclose IP that they've made for you. You want to understand who made it. Were they an employee at the time in the legal sense? Because at law, there's a distinction between employees and independent contractors. So an employee is someone that I hire. I tell them your job is to do software development. They do software development, they develop software. And as part of that employment arrangement, I pay them money and then I own their work product. In an independent contractor situation, I hire someone on an ad hoc basis to develop something for me. They work from home, they turn it in, maybe it's a flat rate or something. That may be an independent contractor. And the ownership of the generated IP legally is different whether they're an employee or an independent contractor. So the nature of your relationship with the person making the intellectual property is very, very important because it may impact whether you own it or don't own it. The other thing that you want to think about is what IP have you licensed in or used by others? So if you are creating something and you're using open source IP as a component of it, you want to know that and you want to keep track of that, because open source does not mean you can do whatever you want with it. Open source means that you are licensing that IP through the open source license agreement. That open source license agreement may require that any IP generated using that open source IP also becomes open source. So it infects your work product. If you leverage open source, it may legally render your subsequent derivative work product also open source. So very important to be aware of that. If you're developing work IP for someone else, they may say that you can't use open source for that reason, or they may say you have to identify what open source is in your product. Similarly, anything that you're licensing from someone else, you're licensing it, even if it's a click-through license agreement, those have legal ramifications. And so you want to know what you're using in creating the IP. There's a distinction between incorporating open source IP into your work product and using open source stuff to create your work product. As an example, I may use a freeware or open source word processor or a text editor, for example. That's a tool that I'm using. That's different than having it embedded into the resultant IP. So I spoke about this. So you want to know the circumstances of the IP generation. Who did it? When did they do it? Were they an employee or independent contractor? What was there an employment agreement in place? Was money paid? Do you have an agreement, specific agreement? So for an example of the company logo, which is an easy example, at the end of the day, you want to see a simple agreement in writing that says, I, the graphic designer, designed this logo, which is shown in the agreement, for company X, and in exchange for $100, the receipt of which is acknowledged, and they sign it, and then you have a good legal evidence that you are now the owner. I'll take a little sidestep here on with logos or any copyright material, source code. There's a separate right in addition to the copyright called a moral right, M-O-R-A-L. Moral right protects the integrity of the work. That's not included when you purchase copyright in a logo. The moral right is not included. You have to have a separate agreement or a separate provision within the agreement that says that the moral rights, and they can't be signed, they can't be sold. They have to be only maintained or waived. So you want to have a waiver of the moral rights that you can do whatever you want with that logo. For example, if you want to modify it down the line, you know, a lot of companies, if you look at history of large historic companies, their logo, their current logo is an evolution of earlier iterations. And you're allowed to do that when you have the waiver of moral rights from the original creator. So the other thing I want to talk about is in management of your IP assets is development agreements. So development agreements, or if you have a funding agreement from, you know, NSERC or NRC or other funding organizations, those agreements may include within them terms about the ownership of the resultant IP. So again, if you create some IP in your list, you're going to say what it is. You're going to say it was developed under a certain development agreement and circumstances of the IP. Sometimes that results in joint ownership of the IP between you and the funding organization. Sometimes you get to own the IP outright yourself. Sometimes you get to own the IP outright yourself with a license back to the funder or to the joint developer. Sometimes that is exclusive or non-exclusive. So this I could spend forever on this slide, but I'll keep it short to say development agreements, particularly joint development agreements, are, and this is outside of the funding agreement, but if you're teaming up with someone else to jointly develop some IP, everybody always says, let's make the IP owned jointly. That creates a whole host of issues. First of all, joint IP is treated differently in the United States as compared to Canada. In some jurisdictions, the joint owner can do whatever they want with it, meaning that they could license it to everyone in the world for a penny, and which completely devalues your joint interest in the IP. So you want to make sure that you're very, very careful about joint IP. It's not this panacea that people think it is. In fact, it's the opposite. I much, much prefer ownership and licensing of the IP, and everyone wants to be the owner and license the other guy. That's not necessarily, you know, like you don't have to be the owner. If the license that you receive is sufficiently robust, it's fine to be the licensee. And so, you know, ownership and licensing arrangement is much, much more, in my view, much more certain and definable than joint ownership, even if you're the licensee. Because a licensee can have every single right that the owner has, even though they're the licensee. It doesn't have to be a subset of what the ownership has, but it's a much more well-defined arrangement. Licenses can be carved up by subject matter, by territory. They can be exclusive, they can be non-exclusive, they can be royalty bearing, non-royalty bearing. If they're exclusive and you're licensing your IP to someone else and you want them to monetize it and then you get a royalty in return, you can do that exclusively. But then if they don't perform, there should be a way to convert it back to a non-exclusive or terminate the license. So for example, you may license it to someone exclusively, but they have to meet a certain sales target every year. And if they don't meet the sales target, then they have to pay you the royalty regardless. And if they fail to do that, the license is terminated, or the license gets converted into a non-exclusive license. So I have one more slide and then I have a question. So the final slide, again, once you know what you have, you should try and protect it. Patent protection, what markets? Is it the type of thing you want to protect? Trademark protection, where is it going to be used? How is it going to be used? Where did the name or logo come from? Do you have protection by agreement? Confidentiality agreements and NDAs are good things, but they are legally binding contracts. They're not, people just think that they're no big deal. They're just as big of a deal as any other legal contract. So I'm going to stop there and go to the chat. And I had a question which I minimized, and now I can't max up.
I'll read it for you.
Sure.
A bit of a different question regarding IP, but wants some perspective. Who owns IP generated by AI models? If I create something using Gen AI, who holds the right to the generated work?
Right. So that's it's a good question. I don't think that's settled at law, and I don't know the answer to that. That's a cutting edge question. Like I say, that's still something that's being analyzed, and I think one thing I can say confidently about it is that it's likely going to receive different treatment in different countries, at least in the near term. So I don't know the answer to that, and any answer I did give could very well flip-flop within the next 1 to 2 years. So that's an open question.
Because there was a follow-up one. So,
Sure.
and what measures should be in place to protect proprietary data and trade secrets when using Gen AI tools?
Well, again, that's a good question. If you're protecting proprietary data, that protection is gone when you disclose the data to someone else. And so the question is, if you're pumping that into some AI, whether it's Gen AI or LLM or something, you're pumping that into it. The question is, have you disclosed it? And so again, open question. I wish I could answer that. People are struggling with this. I do not have an answer to that question. And I know that's also an open question. I know in my firm, for example, with our clients, we have many clients who have instructed us to not pump their data into any AI for that very reason. So their internal legal departments have told us, do not use our data to either train or to be analyzed by an AI model for that very concern.
There was a question about, can you talk about PCT?
PCT, yeah. So PCT is a patent cooperation treaty. It's a mechanism for filing patents in many countries at once. So what you do is you file your patent application through the PCT, and that gives you the ability then to effectively apply to have that patent protected in every one of the PCT countries, which is essentially every country on the planet. You have to then elect, at a certain point, you have to elect which countries you actually want to file in. And then once you elect, those elected countries will then analyze the patent directly. So the rule of thumb is that it makes economic sense to go through the PCT if you're going to file in more than 5 countries. If you're only going to file in 2 countries, it's just easier to file directly into those countries. But with the PCT, you can streamline. It's more expensive on the front end, but if you're going for more than 5, you can streamline the process to some degree. But at the end of the day, each country, Canada, United States, whatever, will make their own analysis and issue their own patent.
And another question, how do I get a patent agent? And is there a recommended resource list, and what support is available for funding? And also a resource list for trademark agents too.
Right. So I'm gonna defer to you on the funding side, Shelley, and you can talk about your work. But on the front end, patent agents are hard to come by in the Atlantic provinces. I am one, but I am not actively doing patent applications. Other than me, I'm not aware of anyone else. So I always refer everyone to firms in Ontario. Gowlings, where I used to work, as an example, have probably 100 patent agents in Canada. And you want to find a patent agent who, not just any patent agent, you want to find a patent agent who knows your subject matter. So for example, and when I was there, I had colleagues that all they did was telecommunications patents. That's all they did. I had another guy who only did pharmaceutical patents. So they really need to know the subject matter. And so you want to find someone who you have to look around, there's lots of patent firms in Ontario. Ottawa is a hotbed of patent activity, Waterloo and Toronto. Outside of that, you have patent agents in other major centers, but you're going to find the most concentration in Ontario and look for someone who has your subject matter expertise. I hand it over to you, Shelley, for what you wanted to comment on and any aspect of the
Perfect.
question.
I'm going to share my screen.
I stopped
Hi,
sharing.
perfect, thank you. Hi, everybody. Shelley Hessian with Springboard, and I am going to go over some sources of funding to help support your intellectual property. So just a little bit about myself. I work for Springboard Atlantic, and we're the network of the 19 post-secondary institutions in Atlantic Canada working to commercialize academic and industry-led research. So if you needed to connect into the post-secondary defined resources to help with an R&D project, we can help you with that. This is the 19 institutions. And then this is a link to Springboard. So we're supported by ACOA and our member institutions, and we have 40 plus industry engagement professionals at post-secondary institutions. So different forms of intellectual property that I'm going to talk about. I specifically work with this one called Elevate IP. It's an innovation, science, and economic development program. It was announced in 2021 to help startups identify what they have for IP, to formalize it, and to monetize it. There's 3 parts to it: IP awareness and education. So we're doing workshops, we offer one-on-one advice. We can help support development of IP strategy and IP strategy implementation. So to be eligible for this program, a startup is less than 10 years old, headquartered in Atlantic Canada. We look at applications quarterly. It's an application and a quote. So to help with IP strategy, which could be the development of strategy, patent searches, freedom to operate, copyright, it could be someone looking over your NDAs, non-disclosure agreements, licensing agreements to find out that you've got IP covered. So the maximum between strategy and implementation, which is the actual filings, Canada, US, and international, a startup could get up to $75,000 at 90% coverage. And the program runs till March 31st, 2026. So just go to the Springboard Atlantic website for more information. The other program that's available that's widely used is the National Research Council Industrial Research Assistance Program. They have a program called IP Assist. You're eligible for this if you're a small and medium-sized enterprise, you're an IRAP client, and you're incorporated. So they've got 3 levels. Level 1 is like office hours. Level 2 is to develop a strategy. Level 3 is to start doing some of those searches and licensing agreement. So if you are an IRAP client, talk to your industrial technology advisor, and then they can actually tell you about the program. Another program, if you are a clean tech company, is the Innovation Asset Collective. They're based out of Ottawa, but they have a national reach, and they do have programming and funding available to small and medium-sized enterprises. Another program available is CAN Export for small and medium-sized enterprises. So if you were exporting, you could get up to $50,000 to help file IP in other countries. Go to the website. I know they're currently not accepting applications, but they will open up again in the new year. And then the final one is the Business Development Bank of Canada, intellectual property-based financing. So they have an envelope of 160 million to help companies with intellectual property. And then this is my contact information. Happy to touch base with you or reach out to me. Happy to answer any questions. So that is kind of a quick summary. I know we've got 2 minutes left, and I'm going to put a quick poll up just to see if you could answer it, to see whether the knowledge and understanding of IP that we've talked about in this session has increased. So we've got a couple of minutes. We'll open it up to maybe any last questions. So Stuart, I'll get you to put your video back on.
There I am. Okay, happy to take any questions.
So there was a question about, so you said there's not very many patent agents in the region. Is there been many trademark agents in the region?
Right. So yes, I'm a trademark agent. Our firm here in Halifax has a couple. Patrick Fitzgerald, my colleague, is a trademark agent. Most large firms in the Atlantic region will have at least one trademark agent. It is something that you should have a registered trademark agent. If you're going to retain someone, they should be a registered trademark agent rather than just a lawyer who happens to have an interest in trademark law. But yeah, they're more accessible. I can tell you that the cost for filing a trademark application can vary between $1,000 and $2,000. I will give you national protection for 10 years, extendable indefinitely, whereas a patent application will be significantly more than that typically.
Perfect. We're at time. I'll pass it back over to Digital Nova Scotia.
Awesome. Thank you so much, Shelley and Stuart, for such an informative session. I think that everyone here has learned something about IP, the IPs and IP systems that they can take away. And I think you guys showed your contact information so that they can reach out to you if they have any questions.
Yes.
Awesome.
And feel free if to send out the slides from me. Can your slides be shared too, Stuart?
Yeah, that's fine.
Okay.
Awesome. Well, thank you everyone for joining us, and we hope you had a great session. We hope you have a great rest of your day.
Great. And I'll send a new, I updated